Alright, watch this closely. What looks like a routine plea hearing is about to turn into a masterclass on how attitude can derail your own case. This starts calm, but it doesn't stay that way.
Anybody threaten you or coerce you in any way?
Kind of.
Okay, what do you mean, kinda?
I don't want to go to jail again, Your Honor.
Okay, but did somebody threaten you to plead?
That answer is wild. Accusing the judge of threatening you during a plea colloquy isn't confidence. It's confusion. Judges are legally required to explain jail exposure. Calling that coercion puts the entire plea at risk.
Yeah, with jail time, Your Honor.
Okay, but who did that?
Well, technically, you, Your Honor.
So here's what I'll do. I'll pass it. Don't talk to Ann.
Mr. Hampton has entered into an agreement with the people, and I'd like to enter that into the record. Your Honor, is it possible to enter into both today, to address both cases today on the record?
That file is not in the courtroom.
Oh, okay, got it.
But I can give you the bill deed that you answered.
Oh, sorry.
But I don't believe it's.
What? Okay.
Talking about bond, that's
And they're pleading another case that's set for prelim.
Yes, yeah. So case 24F55262, just because of the timing with the mental health treatment court evaluation, that one was set for preliminary examination before the evaluation was complete. And that is currently set for exam.
So over there is Ann, right?
Yes.
You know Ann?
Yes.
Okay. So if you had this, that may work out where we could like get rid of two cases and he could plead. I may or may not do it, but usually just go over and ask Ann. Because you asked me on the record, I'll probably say no, because I don't do the filing, so I don't know where it is.
Understood. Yes. So I will.
So would you like to do that today?
I would like to.
So here's what I'll do. I'll pass it. Don't talk to Ann.
Thank you very much, Your Honor.
You're welcome.
Your Honor, sorry. Ashley Bashir on behalf of Mr. Hampton. And in addition to addressing the case directly, we would like to address bond and request that a condition, specifically the home confinement tether, be reconsidered.
Okay, I'll get to that maybe at some point.
So thank you. Yeah.
Right now, I'm trying to get these pleas done.
Thank you.
So my understanding is he's going to plead to count in case ending in 1596. He's going to plead to count 2.
Yes.
Correct? With count 1 being dismissed. That's going to be a guilty plea. Correct, counsel?
Yes.
All right. Then on the other matter, I have a plea form that indicates that the defendant will be pleading guilty to an added count 2 of attempted resisting and obstructing the 1-year offense. Upon a successful plea to that charge, count 1, the resisting and obstructing, would be dismissed. And there is an agreement that the defendant is to go to mental health court. That's the court's full understanding of the agreement.
That's right.
May I have the defendant's sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
State your name.
Brandon Hampton.
All right.
And man, it is this court's understanding that you're going to be pleading guilty to 2 misdemeanor offenses. Is that correct?
Yes.
All right. The first one, in the case ending in 1596, is the charge of aggravated assault. That is a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court costs. You understand that?
Mm-hmm.
Yes?
Yeah.
Okay. You also understand in that case that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 14A2 District Court. You understand that?
Yeah.
Okay. And understanding that on that case, do you still wish to plead guilty?
Yes.
All right. On the other case, it's this the court, since court's understanding, you're going to plead guilty to the charge of attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. Do you understand that?
Yes.
You understand also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo in the 15th District Court. You understand that?
Why are the judges different, Your Honor?
Why are the judges different? Because these allegedly occurred in two separate places. The case that we were just talking about with Judge Valvo, the offense took place in the city of Ann Arbor. And the other case happened in maybe the city of Ypsilanti or, yes, in Ypsi City of Ypsilanti. I'm sorry, Ann Arbor Township. Okay. So they occurred in two separate jurisdictions. Okay. That's why you have two separate judges. But what's going to happen, I think this is probably really the crux of your question. You're going to go to mental health court on these, right?
Yeah.
So Judge Valvo is actually in charge of mental health court. So when that case goes over to her, that will be where it is. You'll have to go before Judge Barr. Judge Barr will do the initial part of the sentencing and then place you on probation to be supervised by the mental health court. Follow that? So it's just a little bit of a process. Both cases, it's anticipated, are going to end up in the same spot.
Okay.
Okay. You got that? Any other questions on that?
I guess it's not like possible for the other case just to go to Valvo as well.
It will get there. It just can't go directly that way.
Okay.
Okay.
For sure.
Anything else? Trust me, we do this all the time. It'll get there. So it'll catch right up to it. Okay. All right. Any other questions you have?
Just the one about bond, but
Yeah, we'll get to that in a moment. All right. So understanding all of that, you still wish to plead guilty to these charges?
yeah.
Okay. So to the charge of aggravated assault, how do you plead?
Guilty.
To the charge of attempted resisting and obstructing, how do you plead?
Guilty.
You understand that by pleading guilty, you will not have a trial of any kind.
Yeah.
All right. You signed an advice of rights form, correct?
Yeah.
Do you have any questions regarding any of those rights?
No.
All right. You see a copy on the podium. Look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
Yes.
All right. Were you on probation at the time of these offenses?
No.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead to these charges?
No.
All right. Anybody threaten you or coerce you in any way?
Kind of.
Okay, what do you mean, kinda?
I don't want to go to jail again, Your Honor.
This is the part where you can literally feel the courtroom shift. Like, everyone went silent. Oh no, he really said that? Claiming the judge is out of line for outlining sentencing options isn't just bizarre, it shows he doesn't understand the basic purpose of a plea hearing. Courts are obligated to make sure the defendant knows exactly what they're risking. That's not intimidation, that's federal procedure. And by framing it as a personal attack, he's not just misreading the moment, he's signaling to the court that he might not be competent to follow through.
This is the exact moment the room shifts. The judge slows down, softens the tone, and starts protecting the record. That's not leniency, that's damage control. Once a defendant sounds unstable or combative, the court has to rethink everything.
Okay, but did somebody threaten you to plead?
Yeah, with jail time, Your Honor.
Okay, but who did that?
Well, technically, you, Your Honor.
Oh,
Mr. Hampton, so,
tell you what. Why don't we pass the matter? Maybe you can talk to him and we'll give this another shot today if we're comfortable with it. Otherwise, the court may not be comfortable with it and we might just blow all of this up and it'll just have to happen another way.
Thank you.
But I'll give you a chance to talk.
That was Judge Simpson going full preschool teacher mode. Slow tone, soft delivery, carefully spaced words, all to avoid triggering a meltdown. And honestly, that's not kindness, it's courtroom control. If a judge senses you're unstable or playing dumb, they'll start laying out groundwork to protect the record from appeal. The moment this guy drifts any further from reality, the court's next move might not be sentencing, it might be a psych eval.
We're back on the record in the case of the people versus Hampton. We're in the middle of taking a plea. And so I stated the terms on the record. And Mr. Hampton, I'm going to ask you a couple questions again. Do anything other than what's been stated here today on the record to get you to plead to these charges?
No,
Has anybody threatened you or coerced you in any way to get you to plead?
no,
You're doing this voluntarily,
yes,
of your own free will,
yes,
and because you believe that you're guilty of these offenses?
yes.
All right. We'll start with case 1596. Paperwork. So, okay, Mr. Hampton, on the date of August 29, 2024, at Washtenaw Community College in Ann Arbor Township, Washtenaw County, State of Michigan, do you recall what happened on that date regarding a Vladimir, is it Parahorov?
I don't know, Your Honor.
All right. Did you get into a fight with somebody?
Oh, I know what happened. I don't know what his name is. It's not like.
Okay. Why don't you tell me what happened then?
Oh, I was trying to take a shower, Your Honor.
Okay. And then what occurred?
When I was in the locker room, he had pushed me up against the wall, hit me in my head, and threw me on the ground. And then broke in my property.
Okay, but before that, did you do anything before that?
No,
Okay.
it wasn't until there were 4 people on top of me, and I was fearing for my life that I bit him, Your Honor.
Okay. So here's what I'll do. Counsel, because I can see the way that this plea's going, it's not going to work. So if you guys want to change, I'm not suggesting you guys want to change things to a no contest. If you want to do whatever, what I will do is I'm back up at 1. I'll call it back up at 1. I think everybody's still going to be here. So, and give you a chance to talk with him, decide whether or not you want to do no contest, please explain what a no contest, go through all of that with him, and then see if we can get this done.
Thank you very, very much, Your Honor. Appreciate it. Thank you.
This is a prime example for me of no good deed goes unpunished. All right, so we'll call it back up at that point. Quarter past these matters again. All right.
We actually, based on the most recent conversation with my client, I will actually seek to adjourn this case for to further advise my client on the offer.
All right.
For the shortest adjournment possible.
February 13th. Both matters.
Thank you very much, Your Honor.
Both matters? Well, that's true. What are we doing with, well, when is the exam set?
Tuesday, the 28th.
Yes, so apologies. We can see, I'd be happy to stip to adjourn that, the exam or for the other case.
Well, you're gonna need a step on the exam.
Yes.
But I only took it because there was gonna be a plea.
And just like that, the deal collapses. What should have been a clean resolution turns into adjournments and uncertainty. All because control mattered more than outcome. So ask yourself, was this about justice or ego?
When do you want the other one adjourned, Chair?
When is the soonest?
I'll set this, I'll adjourn the
After the
1596 I don't. I'll adjourn 1596 to February 6th. The other one is stay on track for a preliminary examination. I understand that people are not going to have the witnesses available, or you need a stipulation to adjourn that out.
Thank you.
Okay.
Thank you, Your Honor.
This whole thing felt less like a court hearing and more like watching someone light their own parachute on fire mid-fall. The plea was a lifeline, clear terms, reduced time, solid deal, and he torched it just to feel like he had control for 5 minutes. What's wild is judges actually want these things to go smoothly. They're not out here begging for chaos, but when a defendant starts rewriting reality in real time, it puts the entire process at risk and wastes hours of legal manpower. That kind of behavior doesn't just hurt the case, it chips away at courtroom efficiency, credibility, and even public trust in the system. And it makes you wonder, should courts start screening harder for mental fitness before pleas are even accepted? Anyways, if you enjoyed the chaos and legal breakdowns, hit like, subscribe, and I'll see you back here tomorrow for another case that probably didn't need to be this messy. Thank you guys so much for watching, and I'll catch you in the next one.